Hey everybody, so today we're going to answer the question, when is the right time to file a provisional patent application? Hi everybody, I'm JD Houvener, owner, founder, and patent attorney here at Bold Patents Law Firm. Also the author of Bold Ideas, The Inventor's Guide to Patents. The book's available for free if you book a free discovery call on our website. Also, if you're just getting started, check out the link below. It's our free Inventor kit. This gets you started on your journey toward invention. All right, let's dig into this question about provisional patent applications, and this is talking about utility patents. Utility patents are one of two major types of patents that are out there for the U.S. inventors. There are actually three total. Utility patents are those that are most prevalent, you see most often and hear about. These protect inventors and owners of patents for utility patenting. They have functional benefits. And most inventions have functionality, and there's a really low bar in terms of what is required to show utility. And so a lot of inventions want to get protection this way because you can protect more than one feature, more than one element with different types of materials, different ways it can be structured, and have nice broad coverage. The other type of patent is a design patent, which covers just the way something looks. And so there are far fewer of these issued, just over 1 million as of today, whereas there have been over 12 million utility patents filed. The third type I mentioned really quickly is called a plant patent, and you can get a patent on a specific biological structure for a plant, a botanical plant. So let's go back to utility patents. And a type of utility patent is a provisional. Provisional patent applications are those that are less formal and require a lot less rigor in terms of what's required for the specification. The written description. The written description is the English words and the drawings, pictures, and images you show to say what your invention is. And usually, in a non-provisional, a formal application, that's what the examiner would look at to say, is this new? Is this obvious? And can we allow this to become a issued patent? But a provisional will just provide the basis and provide you the all-important filing date. So that's what you hear a lot about. If someone has been patent pending, maybe now they filed a provisional, they have locked in that date, and they have now just 1 year to file a non-provisional patent application to secure that formal application, claiming the priority back up to a year ago when they filed their provisional. Now, when is the right time to file a provisional? I say as soon as you're able to confirm that what you've invented is truly novel and non-obvious over the prior art, meaning you've done a diligent patent search on your own, hired an expert patent attorney. Second, if you have no reason, or if you have a reason, I should say, to further refine your invention, or you're not quite ready to file the non-provisional. Now, there's lots of reasons why you might not be ready. Financial, maybe you need more time, investment, or you need more engineering skill. You need to actually go build the product to prototype it and convince yourself that what you've invented is truly what will actually happen. Or you want to prove it to yourself that it works the way you think it does. And so by going to work that year, building it out, convincing yourself, and maybe even selling it and convincing customers that what you've come up with is unique and valuable, then you move forward to the non-provisional step. So, like I said, make sure you've done that diligence about, is what you've invented unique? Is it patentable? And then are you in the right timeline in terms of your development of your invention? Those are the two big things I say. If you're not far enough along in your invention, you aren't totally ready to lock in all aspects of your invention with a non-provisional. A provisional can be an awesome option for you. So if you have any questions about what type of application is best for you, please do give us a call. Visit our website, boldpatents.com. Download that link below. Hop on to our Bold Inventor kit. Get started with us today. I'm JD Houvener, owner, founder here at Bold Patents Law Firm. Have a great day. Go big, go bold.